Tapi banyak juga ya semester 2. Berapa
Banyak
paralel sekarang kelasnya?
banget.
Dulu kayaknya sampai
600 ya Kak, 600.
ya, dulu tuh
600-an orang.
dulu angkatan kita sampai H ya, kalau nggak
Sampai
salah.
H. Sekarang
Sekarang
kan ada kelas N,
II.
kelas tuh kelas N.
N,
Kelas tuh kelas N. Kelas N.
satu dosen ngajar berapa itu? Ngajar
Dibikin
berapa
loh.
mata kuliah?
Sekarang sudah lumayan. Sekarang satu kelas pokoknya maksimal 40. Dulu sempat 80 ya Mbak Ula ya.
So,
Satu
sempat
kelas.
pusing
Sempat
dosennya.
70,
Kayak ngisi
80.
seminar.
Oke, nggak maksudku
Belum koreksinya.
satu orang dosen bisa berapa kelas yang diajar?
Kebetulan saya satu kelas, ada yang 2 kelas paralel. Ya, kebetulan saya
Oh,
sih satu. Ada yang mata kuliah hukum laut, saya 2 kelas.
Aku
Itu
itu 2
sampai
kelas
kelas.
HI. HI 2
Iya,
kelas.
HI 2
Yang
kelas,
HI
saya
2
satu
kelas.
kelas.
Laut 1.
gitu ya.
Saya laut yang dapat kebagian 2 kelas. Entahlah. Ya, banyak peminat.
Ya,
Saya tahu
alhamdulillah.
kalau di Jindal itu mungkin nggak sebanyak kita ya kali ya, karena populasinya kan di Indonesia banyak. Atau di sana banyak juga kali ya.
Banyak, alhamdulillah. Ini kelas human rights 60, mata kuliah wajib biasanya 60, 50, segitu kan kok.
Ya.
Gitu.
Sebenarnya kalau di UB kan ada human rights law itu wajib. Mahasiswa kelas semester berapa ya? Mungkin semester 5 kali human rights law. Ya. Tapi tergantung yang ngajar kalau human rights law itu ya. Kalau yang ngajar dosen-dosen HI pasti kita selipkan international human rights law-nya. Tapi kalau mungkin dosen yang bukan HI, mereka purely ngajarin yang human rights versi Indonesia, Undang-Undang
Iya, iya.
3999. Jadi kalau yang ngajar dosen HI pasti diselipin International Human Rights Law gimana, karena kan nggak semua mereka akan mengambil mata kuliah HI kan.
Betul.
Kalau yang mengambil mata kuliah HI otomatis dia pasti akan dapat International Human Rights Law. Tapi yang mahasiswa yang nggak konsentrasi HI, nah di situ kita selipin materi-materi sedikit tentang ya mungkin pengantar ya, gimana mekanisme internasional itu tentang HAM-nya gimana ya, mekanismenya ini ya sebatas itu. Tapi kalau nanti ya mungkin ya Niar, atau hari ini atau besok ya, atau sudah yang
Besok yang internasional
International Human Rights Law kan ada sendiri.
Sama anak besok sama anak
Bilstaf ya, sama ya itu mata kuliah wajib konsentrasi.
Oh ya, maksudnya konsentrasi.
Masuknya di konsentrasi. Kalau yang mata kuliah wajib biasanya human rights law aja, cuman ya kalau dosennya bukan yang dari HI nggak akan banyak pasti banyaknya yang versi Indonesianya.
Iya, iya. Iya, sebenarnya kan saya bukan orang HI, dulu kan pidana.
Pidana
Tapi
ya?
tapi
ya pidana ya.
Karena di sini hitungannya dosen asing kan, jadi memang diberikannya mata kuliah yang ada unsur internasional
iya,
gitu.
iya,
Karena
mesti gitu.
kalau ngajar pidana ya jatuhannya pidana India, dan kita kan nggak nguasain gitu kan, nanti malah tanda kutip saingan sama yang orang lokal ya, itu kan jatahnya mereka.
Tapi kamu wis pantes kok ya, wis membaur kayaknya ini sama orang India.
Ya tinggal bahasa aja kan. Tinggal bahasa aja yang belum.
Iya, tapi kan orang India kan bahasa Inggris kan mereka kan, maksudnya
memang mereka nggak punya bahasa nasional, jadi memang campur-campur, bahasa Inggris ada, bahasa Hindi juga.
Bahasa Hindi ya. Oke. Can we start, Bu Yasnia, Pak Eka? Okay. Good day, everybody. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Today we will get a 3-in-1 program with Mr. Eka Jaya. Still in the same subject in international law, we will discuss about jurisdictions. I'm sure that in the previous day you already know about Pak Eka Putra from Jindal Global University. He is expert in international human rights law and also international law. So we will have discussed about the subject today, and hopefully you all be active participate. And for Mr. Eka, I will give you maybe 30 or 45 minutes to deliver the material for today, and will followed by question and answer from a student. Thank you.
Thank you, Bula. Good morning, everyone. Assalamualaikum warahmatullahi wabarakatuh. So I guess I have to deliver the lecture today in English as already initiated by Ibu Ula. I believe all of the students here would not mind with I'm using English because my presentation slide is already in English anyway. So we continuing our discussion from the first day on Tuesday, or 2 days ago. It was about the international treaty law on human rights. 1 second, just give me give me 1 second to share the screen. Everybody can see it, right? Okay. So as I said earlier, we are going to talk about state jurisdiction on human rights cases, or part of this topic is actually continuing our discussion on Tuesday, which was about international treaty law. So it's more on the how international law can formulate it, or after drafting and signing and ratifying international treaties, especially international treaties on human rights law, then how this the law can be implemented. In this case, is how then also it is also going to talk about how then each states, or in this particular case, is the jurisdiction of the state whenever they're having conflict or human rights cases. So here we go with the discussion on state jurisdiction on human rights cases. We have to understand that part of the issue of the international human rights law, or I made it here as an abbreviation, as in IHRL, or international human rights law. There are scope of application of international human rights law, which will be consisting these two elements. The first one is about state responsibility, especially when a state is committed human rights violation, or even human right or even international criminal offenses, which then violating international criminal law as well. The second one is about jurisdiction. It's talking about the authority or the claim of authority of one country or one state over something. It may be about an individual who is a national of a country, of those country, or even for non-national, whether it's occur or happened in the territory of the country or not. So that is the scope of application of international human rights law. In this matter is about international human rights law treaties. 2 days ago, we talked about several major convention of international human rights laws. Two of them that I was talk about are the majors were international covenant on civil and political rights, or ICCPR. And the second one is ICSCR, International Covenant on Economic and Social Rights. There are others international convention or covenants, as I mentioned as well. But I think that I think that on the top of our head, when we're talking about international human rights law treaties, it will be ICCPR and ICSCR, without disregarding the others, because that's also important as well, because that's giving more detail. Back to this. So again, the scope of application of international human rights law will be on the state responsibility and jurisdiction. And jurisdiction itself would be mainly connected with what is called state sovereignty. What is state sovereignty? In Indonesia, you will call it kedaulatan. So again, it's all about how then a state or country, a government can claim their authority by at least two things. The first one is drafting or making a law, in this case, national law or domestic laws. Like in Indonesia, you have Criminal Code Act or KUHP. That is part of the internal jurisdiction. that is part of the state sovereignty in implementing their internal jurisdiction, which then part of the responsibility and part of the authority is, drafting or making law that will be applied for all the nationals who are the citizen of the country. For example, KUHP in Indonesia, which applies to all of Indonesian who live in the country. It may also applies for those who are non-nationals, for the domestic or non-national, if the person or the non-national who are living in the country committed some crimes that apparently will be called as a criminal offense or violation on the domestic law or national laws. One pretty good example that I can provide here. I don't know if you guys read the Compass newspaper today, but there was an article. But even though you're not, I believe you already heard this from social media posts that very loud and viral talking about this issue. So in Bali, there are a lot of tourists from Western countries, European countries, or even maybe from the US, that they are moving from their home country, moving to Bali. With initially they were holding tourist visa, entering our country, entering Bali with tourist visa, but then their visa, their tourist visa was expired. They did not extend or reapply for other type of visa, or maybe extend the tourist visa, and they actually illegally living in our country in Bali. But then they try to make some money by being so-called yogi or yoga teacher, or digital nomad, people who are giving training online and moving to one place to another place. And to some extent, some of those people, some of those tourists maybe can also violating crimes, not just because they are living and staying illegally in our country, but they also maybe harming the public order, making public disturbance, as you may see in some of the videos that went viral in the recent past of months, or maybe even before that. That is actually one of the example how whenever the government or our authority, Indonesian authority, trying to arrest them, trying to getting them caught, it's actually part of the Indonesian to claim their jurisdiction, or to exercise their jurisdiction, and then to show that this country has state sovereignty. So for all of you, you cannot just coming and moving here, living here illegally, and making some money without any proper document, without any legal document, and then doing a lot of things just because you can, because this country has law. So that is, I think, actually one of the pretty good example in show that jurisdiction, any country, wherever it is, it's of course have jurisdiction in this matter. So again, jurisdiction would be mainly connected with state sovereignty. Jurisdiction will also talk about how then the control over territorial. So specifically talking about geographical aspect. So like Indonesian is archipelago island. I don't know how exactly the numbers of the island we have right now, but last time I checked, it is 17,000 island. It may be more right now. So whenever we're talking about jurisdiction from those aspects, it's actually talking about the territory control, not just over the land, but also over the sea. Well, there is also International Law Treaty, which is in 1982 called as UNCLOS, or United Nations Law on the Convention of the Sea, which is also regulating about territorial control. But whenever it's about the territorial sea for each country or each states, but specifically when we determine the state jurisdiction, of course, jurisdiction will also assess not just territorial control over the land, but also over the sea, and maybe also, and to some extent, it's also territorial control over the space or sky. And Control also will come from a jurisdiction, which is control over individual, as I said earlier. So it can be over the nationals with its domestic and national law, and it may be also over non-national. Hence, then we can say that there are a couple of principles in the state jurisdiction that could be depicting how this territorial control and also control over individuals that may be helpful for you to imagining what is jurisdiction in this matter. So some of the principle here, the first one, the main and the first one, it's territoriality, where the jurisdiction or the claim of authority take place on the territory through legislation. So simply whenever a country or a state making or drafting legislation, then it's actually saying that this is the part of our territory, and this is the legislation that will be taking place, and or controlling the territory on this legislation, and then who are going to be responsible, and then to what kind of crimes or to what kind of violation that this legislation will be implemented. So that will be the main principle of territoriality when we're talking about state jurisdiction. So it's actually pretty simple because it's just saying over the territory of a country or a state, right? So that would be the first principle. The second one is about nationality. Nationality is again another simple determination of jurisdiction. So a country can claim their authority over the national or the citizen wherever they are. So even though they are, let's say, if there is a criminal convicted running from Indonesia to another country, but he or she committed the crime in Indonesia, we can have them to be prosecuted, getting them caught, especially if the country where this person running for and our country Indonesia have this extradition agreement or extradition treaty, then it will be simpler with those methods, because then Indonesia can have the country to help the government to bring back this person because he's convicted a criminal offense in Indonesia and then violating the national law. So this person should be prosecuted in our home country in Indonesia, because in criminal law terms, the locus delicti or the location of the crime was happening in Indonesia, not in other country. It will be differently apply if the person running or moving over from Indonesia to another country, let's say Malaysia, and this person committed a crime in those country, in Malaysia, not in Indonesia. The prosecution or the claim jurisdiction will be the passive personality, or even the protection, because it's the protection in here is protecting based on the which harm or which country is getting over the harm because of the crimes committed by this person. So the claim jurisdiction based on the protection principle was actually came from the activities that may endanger this national or this citizen in those countries. So let's say with the previous example, so a person from Indonesia moving to Malaysia and he committed crime over there, then this person should be prosecuted based on the Malaysian law. The previous example that I used with Bali, and then Western countries, tourist people who come to Bali and to our country, they're committing crime in here, and then based on the principle of protection and also territoriality, we can also use or claim this state jurisdiction based on these two principles. So then it's actually based on that this principle that depends on the situation, depends on the crime, depends on the national, that this person may also should be committed and then implementing the laws or the state jurisdiction. The passive personality, as I said earlier, this one is among the international law scholars or international law debate. If I'm not mistaken, it's pretty. I think it's rarely implemented because there are some debate or some pros and cons regarding using of this principle, but by definition it's actually the claim of jurisdiction again of a prosecution based on the harm to state nationals, maybe kind of similar, but the implementation is actually kind of complicated whenever it goes to applying this perspective personality. However, maybe with some cases we can see later on, because I might be citing one or two cases to see whether of these, not all of them for all of these 5 principles, but at least to show all of you here that how then we can apply the state jurisdiction based on these 5 principles. The next one and the last one on state jurisdiction principle is on the universality, which then maybe the latest one or the recent one. Universality is regardless of the territory and nationals, so that all states can legislate and prosecute. Here's the thing with the international law principle, and then we can say that based on this universality principle, then international law can be implemented and can be used to prosecuting someone regardless of where the crime is occurred and who is the person or from which country this person is committing came from, who is committing crime. Example of this universality principle is, for example, aggression, war crimes, genocide. It's part of base of universality. However, to some extent, with again depends or case by case. Sometimes those kind of crime, aggression, crimes against humanity, genocide, war crimes, it may be also based on territoriality principle or protection as well. I have to cite depends and case by case terms, because as a law scholars, all of us, usually we cannot just simply saying that this is the principle and this will be rigid, because to some extent what is theoretically said or what the law said usually going to be differently implemented, looking on this on the base of the situation. Again, we can, maybe this will be helpful whenever we are talking about some cases here. Let me just stop right there. So I'm going to give you chance if any of you would like to asking question or have comment or feedback to what I just explained earlier. Anybody? Yes, please.
First of all,
Ya,
thank you.
Traineri.
Yeah, Bu. My name is Trenary, and my question is that if the territorial conducted by a legislation, does that mean the country territorials pardon? So my question is, if okay, can I use Indonesia?
Sure, go ahead.
Oke.
Jadi kalau misalnya teritorial itu bisa apa namanya? Kalau jurisdiksi itu ada, bagaimana bisa Pulau Sipadan dan Ligitan ini bisa berpindah tangan gitu? Misalnya, I mean, how does that work?
Okay, would you directly want to respond or answer, or we just let it go and wait for another questions?
Yeah, let me just respond this one, and
Alright.
then we can proceed to the next one.
Okay.
So Sipadan Ligitan is actually a pretty good example, but yeah, there's another principle I think that might be overlooked in terms of exercising jurisdiction, not just in Sipadan Ligitan case, but other case where claiming over some territory, is that whether how far or how much a country who would like to claim this exercise jurisdiction has been, I'm trying to find a correct and delicate words here. implementing their policy and implementing their governance over that regions. So I think, according to the ICC, or according to the ICC decision, if I'm not mistaken, that was not the case on Sipadan Ligitan. So Indonesia was not properly apply their governance policy and system on Sipadan Ligitan, and then that's why we lost the regions. That was what I am understanding based on the decision. So if I can use another simple analogy, batik were once tried to be claimed by another. This is not on the terms of international law and jurisdiction, but it's more on intellectual property. But I would like to talk this as an analogy to the example of how far we can claim something, but we never properly use that, and then it was claimed by someone else. So batik was once tried to be claimed by another country, but we ourselves, Indonesian, rarely wear batik. We only wear batik, as a formal dress, maybe only on Friday. We may also not really understand the history and all the elements of culture of batik. So when another country try to claim batik over us, I'm not saying that's right. I'm not saying that's correct, but I'm saying that it's maybe could be happen or could be justified because we ourselves not properly preserving batik as our local culture or heritage. Same thing go back to your question, is Sipadan and Ligitan. We angry, we upset those regions, those islands were taking over from us, but we were not properly, the government, especially in this case, were not properly exercising the jurisdiction with the government's policy, with their daily basis were affected by other countries' policy instead of Indonesian government policy, by sharing resources or maybe funding or maybe infrastructure and facilities. So that's what happened in the case of Sipadan and Ligitan. And according to the international law, that it's actually could be happen. So not just on the base of the territoriality principle, but also how far a country can exercising this jurisdiction by, in addition to drafting a law, but also, how can this local citizen in that region feeling the presence of the government from which country? And then again, it's adding the reason why then Sipadan Ligitan is lost from our region, Indonesia. So I hope that's answer your question.
Yeah, thank you, Pak Eka. This because I really put some highlight in Sipadan Ligitan cases is because we don't have effective governance in the Sipadan and Ligitan Island, because we only claim about the territory, but we don't give any more attention to the people in the Sipadan and Ligitan, and the international court make decision that's Indonesia. It's not really the government that how care to the people in the Sipadan and Ligitan. So they will give to the Malaysia because Malaysia have more effective governance there. So the people speak Malaysia, their currency is Malaysia, and everything there is based on Malaysian rules. So the international court give Sipadan Ligitan to the Malaysia. I think this is the important case that we have to learn about how we have to make strong effort to because we have a lot of islands that we have to protect them all. So thank you, Pak Eka, for the second question. This is from Rafif Ramadan. Yeah, you can ask with Bahasa or English.
Okay, thank you. Good morning, sir. Well, thank you for the opportunity to ask question of the presenters. I have a question, sir. Jurisdiction is closely related to sovereignty. Jurisdiction also applies to principle of non-intervention from other countries, right? What is the jurisdiction of Ukraine, of Palestine, where there is a territorial conflict? How does international law view this? Thank you, sir.
Okay, another great examples from Rafif's question, I think, for Palestine and also Ukraine. I was actually going to explain Ukraine later as one of the example, but thank you for the question, so I can discuss this earlier. So let me briefly go over with Palestine. So there are two advisory opinions from ICG. The first one in 1950s regarding the wall in Palestine, and then claiming not claiming based on that advisory opinion from ICG, it actually emphasizing that the territory of the territory that were disputed between Israel and Palestine was actually for Palestine. And the second one is still going on right now. I think it is start in February or March. The second advisory opinion from ICG is about the occupation from Israel against Palestine territory. It's still going on right now. But so far, what I see from those advisory opinion of ICG, it's actually in favor or supporting Palestine. The problem is in the implementation. How then? Because again, it's advisory opinion, so it's not as powerful as a court decision or ICC, as maybe war crimes or aggression and so on and so forth. So that is the problem. I think it's happening with Palestine conflict, Palestine and also Israel. The second part of your question regarding Ukraine. So in March 17, ICC, so not ICG, ICC, International Criminal Court, issue a warrant arrest to Vladimir Putin, the president of Russia, and the head of, I forgot the official title, but Maria something for the name. But both are we know as the public official or the government's official from Russia. Since the conflict or the war started, depends on how you see it, because I discussed this with my student in India when I use the term of war. Some of them disagree. When I use the term conflict, some of them also disagree because some of them think this is proxy war. Anyway, since this conflict in Ukraine between Ukraine and Russia started a year ago, there are 40 or 50 countries already filed intervention to the ICG for this situation in favor of Ukraine. But over the territory or the jurisdiction that we're talking about here, let me see. I think I have it some here. Okay, so ICC issue a warrant for both of government official of Russia. The problem is both Russia and Ukraine are not member of ICC and also are not ratifying the Rome Statute of ICC, which is actually a problem. However, let me show you over here. According to, this is the ICC statute. According to Article 12 of the precondition of exercise of jurisdiction, Article 12, Section 3, you can see here, even though if the state, as in Ukraine, it's not a part of ICC, was not ratifying the ICC statute, they can still asking ICC to investigating and prosecute the crime to Russia, because Ukraine already accept the exercise of jurisdiction. And this was happened not in 2022, but this already happened in 2013 and 2014. So there was a conflict in Ukraine in this year, and then they were trying, and Ukraine then accepting ICC jurisdiction. So according to this situation, according to Ukraine situation, if we can use this as a precedence or, one of the basic or reasoning or grounds, then actually under the ICC issuing a warrant arrest for those two government officials, I think Vladimir Putin and also Maria Lvova-Belova, they actually can prosecute, investigate, arrest, even prosecute these two persons, because Ukraine already recognized the ICC jurisdiction. So even though Russia and Ukraine did not ratify the Rome Statute, ICC can actually prosecute them. The problem is about the implementation, because when we're talking about, this is the law, this is like, law on text. When we're talking about this situation, Russia and Ukraine, we're going to talk something bigger than that, political relationship. The crime maybe clearly happened in Ukraine territory, So that is another reason how then ICC can also prosecute Russia's official, not just and in addition that Ukraine already recognized the ICC jurisdiction. But again, there is a bigger problem whether ICC are willing to prosecute them because Russia has the veto for the ICC and also UN Security Council, and also there is a lot of political relationship with some of the pretty big countries. Later this year, Russia is coming to India as part of G20 summit. India is not part of the, or is not member of ICC. But according to universality, whether India would like to willing to report Vladimir Putin or Russia here for the war crimes, or maybe some other countries would willing to report or willing to helping ICC to arrest Vladimir Putin. That will be affecting a lot of things because Russia is one of the big country and also one of the influential countries. To show you how this big influential of Russia during the winter, Russia is actually supplying a lot of gas to most of the maybe 50 or 60% of to the European countries. So during the winter, a lot of European countries actually relying the sources of gas to can be sustaining or surviving during the winter, which is really cool. So just seeing by one of those simple facts, it's actually can be significantly affect to how then this is going to be applied in Russia and Ukraine conflict. So again, what I was trying to say to you is that to answer your question, based on law, on tax, all of those provision, all of those regulation already there. So ICC just can simply enforce that. But right now, the hand is on the ICC, whether they are willing to do that or not, because it's going to be affect international relation, political aspect as well. But on the legal reason, all of the valid and ground reason, it's already there. Okay, so I hope that's answering your question.
Okay, thank you, Pak Eka. Because if we want to discuss about the Ukraine and Russia, it will be long discussions, basically, because we have many aspects to discuss. Thank you, Raffi. Maybe another questions? Ada pertanyaan lagi, mahasiswa?
Saya masih penasaran mengenai power dari Rusia dan Israel, Pak. Maaf untuk bahasa Indonesia. Apakah Rusia dan Israel ini memiliki kekuatan super, Pak? Maksudnya
kekuatan super.
Maksudnya itu
supranatural, Power Rangers. Oke.
Jadi Israel ini dalam konflik wilayah terhadap Palestina ini, negara-negara luar ini baru menyadari gitu, Pak. Lalu lantas dari dulu itu nggak ada pergerakannya gitu, Pak. Sampai sekarang pun PBB baru menyadari gitu bahwa hal yang dilakukan Israel itu salah. Nah, itu gimana hukum internasional memandang hal ini, Pak?
Well, actually tricky question, and anyway, let me just put it this way. So you're right to some extent that there might be something to overlook beyond the conflict of Palestine and Israel. I think when you're asking and maybe subtly compare between Russia, Ukraine, and Palestine, Israel, when Ukraine get attacked by Russia, all over the media turn over their attention towards them, right? All over the eyes of the people in the world turning over to the side of Russia and Ukraine. But no one bats an eye to Palestine and Israel whenever those happen. I mean, Ukraine maybe have been experiencing the aggression or let's say occupation over territory from Russia for years, but Palestine, it's already happened, like way before that conflict. But again, no one bats an eye whenever that's happened. I do not know how to answer about the superpower, what you're talking about, because I'm not the expert of international relation and international political. But what I see is that maybe there is an element whether the Western countries or all of those countries that are supporting either Ukraine or Russia or Palestine and Israel, especially Israel and Russia, here is getting benefit from them. For example, the country that I'm living right now, India. India has pretty good diplomatic relationship with Israel. Even my university right now has the Center of Israel Studies. So imagine if I'm working in Indonesia, that would not be happen. So there is something that maybe benefit from them by getting those pretty good diplomatic relationship. Same goes, like, for example, with the U.S. country and other countries that might be supporting Russia. I'm not sure I'm answering properly to your question or giving you proper good answer, but at least there are something that may be beyond our view or perspective that may be giving them benefit in terms of over this conflict between Russia and Ukraine and also Israel and Palestine. So I think that will be all for the answer. Okay.
Thank you. Maybe you can continue your lecture, or we will discuss it again later after you deliver your material.
Okay, so thank you again for the question. So let me proceed with the lecture. I'm going to share the screen again. So earlier we talked about the principle, but I would like to giving more elaboration on this principle. So the nationality principle, as I said, is actually implemented to the nationals or the citizens who can be claim who state can claim over the authority or the jurisdiction based on the national or the nationality of the person or individual, and to see whether this individual has a nationality or citizenship of one country. We can see it from two perspectives. Is the first one is then by the descendants or from the parents. So if the parents are Indonesian national or Indonesians, then we can, according to this principle, we can say that a person is an Indonesian as well, because he descend the nationality from the parent, because the parents are both from Indonesia. The second is simply by being born within the territory of the state. For example, in the U.S., if you have a baby, if you are delivering a baby or a baby was born in the U.S., according to the U.S. law, this baby will be based on the second principle will be simply being the U.S. citizen. But since let's say if the parents are both Indonesians, which this also happens to one of my friends when I was in the U.S. as well. So the third children is born in the U.S., but both of the parents are Indonesians. So whenever this kid will be 18, 18, she can choose their nationality. She can choose whether she can be whether American or she can be an Indonesian as well. Well, maybe the parents, I think, or I believe, will be hoping that she will be choosing to be Indonesian, because the parents are still Indonesian and they are moving back to Indonesia right now. But because of the law, because the child was born in the United States, so we can say that it's kind of having this kid having two nationality or two citizenship right now, until when she turning 18, she can choose which one of the citizenship she would like to having permanently, whether American or Indonesian. But those actually, I'm talking about this principle to show you how this nationality principle play important role in the state jurisdiction as well, or the jurisdiction principle based on the nationality principle. Second thing I would like to talk, it was the earlier about the passive personality principle, is when a state may claim jurisdiction to try to an individual for offense committed abroad, but maybe affecting or will affect national of the state. So again, to giving more elaboration is that a state or a country can claim jurisdiction, but the person actually committing the crime abroad, and according to the territoriality, it's supposed to be the jurisdiction of the country where the person is committing the crime. But if applying this passive personality principle, then the country where this person came from can also claim jurisdiction. This is the part where I thought that is kind of a little bit controversial, because there is actually two principle of jurisdiction conflicted each other. The first one is the territoriality, and the second one is the passive personality. Who is going to be taking over this jurisdiction claim is, again, maybe case by case. I maybe do not have any specific or particular example, but this will be another principle that is also part of state jurisdiction, because then states try to claim the jurisdiction of one individual, even though the crime is not affecting or giving harm to the country where this person came from, but instead it's committed outside of the country, outside of the territory. But because of the interest of the country, then the country where this person came from would like to bring over or taking over the judicial process. Okay. The next one is the protection principle that I would like to give you more elaboration. I believe you already heard about the term aliens here, but when I put aliens here, it's not alien as you've seen in the movie, all of those Hollywood movies. To give you some context, the immigration law, the general immigration law in the US, and also I think in the UK, is actually using term alien for all of the non-national. So me, whenever I took my doctoral study in the US, I will be called as an alien. Not because I'm from the space or using UFO to come to the US, no, but simply because I'm not a non-national of US. I'm not American, I'm from Indonesia. I moved over to US to study there and to living and working there. So I'm an alien based on their immigration law. So actually the Hollywood movies actually using the term of alien to depicting extraterrestrial from outer space by using the term from immigration law. Okay, so that's actually the origin of the term aliens, if you haven't heard about that. So again, back to this slide. So the protective principle is that, again, the claim of jurisdiction or exercising jurisdiction over a non-national or aliens or foreign people who come from a country and then who committed an act abroad which is deemed prejudicial to the country. So it's actually simply trying to protecting the interest of the country where the country is came from. All right. The last one, sorry. The last one to be elaborated is about the universality principle that I was talked about earlier. So each and every state has jurisdiction to try particular offenses. And then, I mean, anyone, not just an individual, but also country, can committed a crime, can committed an offenses. And then the universality principle will be applied in here, as I said earlier, with war crime, aggression, and other examples, because the basis for this principle, universality, that our crimes involved are regarded as particularly offensive to the international community as a whole. The example of Yugoslavia conflict or war that started in 1991 until 2000 or 2001. Another example is Rwanda. We can say that it's because in Rwanda it was a genocide between Tutsi and Hutu ethnic in 1994. We can see that it's based, yes, there is a territorial conflict as well, but with the genocide situation that conducted by Tutsi to Hutu, It was actually fall to the category of this universal principle, because genocide, ethnic cleansing, Tutsi to Hutu, and then it wasn't not over the time of war. I mean, there are no wars. So Tutsi and Hutu in 1994 or early 90s in Rwanda the crimes against humanity in here is not, or the crime itself is not happening during the period of war. So Tutsi and Hutu was actually already having a peace agreement between both of them, the ethnic Tutsi and Hutu in Rwanda. So they already having peace agreement, and they already, dividing that Tutsi will be, cattling, peternakan, and then Hutu will be farming or pertanian. But then something happened because the president of Rwanda, which is, if I'm not mistaken, is from Tutsi ethnic, was killing an airplane, and then the airplane was crashed or something like that, an accident or crash. And then that sparked the conflict again. So it was actually not starting from a war, but then because they were angry and upset with that situation, they are attacking Hutu, and then the crimes against humanity, it's happened. So I'm using the crimes against humanity because differently with war crimes, if war crimes, the genocide, the ethnic cleansing happening during the period of war, but crimes against humanity, all of those, the thing that happen in war crimes, genocide, ethnic cleansing, torture, slavery, happens, but not in the war times. That's the difference. So once it's happened during the war for war crimes, another one, crime against humanity, is happening as well, but not during the war. So that is actually happening. Tutsi and Hutu, Rwanda conflict is also encouraged, or having the international law to establishing international tribunal for Rwanda conflict after in 2001, if I'm mistaken, with the Yugoslavian conflict. So before ICC, before the Rome Statute in ICC, there were already two tribunal based on those conflict, Yugoslavian and also Rwanda. So, but the ICC were needed by international community in regards for the international community needing some more firm form of international criminal court that more firm and permanent in the form of ICC that based on Rome Statute in 1998. So if you compare the content itself, Rome Statute has about 130 articles, but for Rwanda and Yugoslavian Tribunal Court, it only has 20 or 30 articles in its tribunal's convention or document. So it's actually giving or providing more extensive protection for International Criminal Court based on this universality principle. Another thing that I have also to talk about is the extraterritoriality principle. It's another jurisdiction that kind of reason as well. But in this extraterritoriality principle is that state can make and apply and enforce rules of conduct in respect of person, property, or even beyond its territory. So it's not about, as you can see, it's not about prosecution actually. It's not about prosecution per se, but it's more on the how a state can make, apply, and enforce the rules of conduct. So it may not only about the criminal, but it can be also about other aspect of law like civil law and administrative law and so on and so forth. The example of this is on the diplomatic convention, based on the diplomatic convention of relation in 1961. So there are a diplomatic immunity. The first one, inviolability, and the second one is immunity itself. It's actually applied to head of state and also diplomat officer or diplomat in embassy who is located in other countries. For example, Indonesian embassy in Malaysia or Indonesian embassy in other countries. Those diplomat agents actually will be having these two immunity. What is inviolability is that they are going not to be liable for any form of arrest or detention. That's the first one. The second one, for the immunity, they will be protected from the jurisdiction of a state where this agent performed their function. So let's say if there is an Indonesian diplomat who is working in Indonesian embassy in Malaysia, this person, this diplomat agent, will be protected from the jurisdiction of Malaysian law, because the one that is going to claim over this individual is the Indonesian law, not the Malaysian law, because the Indonesian embassy itself is actually the extension of the territoriality of Indonesia from the Indonesian country to the Indonesian embassy building, or which is located in Malaysia. So that is how extraterritoriality defined. So it's not about the prosecution, it's actually, but it's more on the how then the law can be enforced, apply and enforced for those people or even property, which is going to be happen in the in this context is diplomatic relation and diplomatic agents. So there goes two of the diplomatic in the international relation, inviolability and also immunity. Now, for this part, actually about the question about the jurisdiction apply, I think I already over this. So let me just proceed to the next one. Okay, so this one is the case. Or before I go to the case, is there anyone who would like to ask question again? Let me just stop right there.
Ya, pertanyaan mahasiswa? We still have 15 minutes more. Ya. Ada pertanyaan mahasiswa? Maybe you can continue.
Okay, so just giving the cases as the example before I wrap up this first session. So the first case that I would like to talk about is Lotus case, or the France versus Turkey. So this was happened before ICJ. So ICJ, the International Court of Justice, was formerly named PCIJ, or Permanent Court International of Justice. I think it was in 1920s, early 1920s for this case, 1922, if I'm not mistaken. France versus Turkey. So there was a collision course in the high sea. So high sea is like Laut Lepas, so not the sea that was part of territory of any country. So it's beyond the territory of any country. So that's why it's called high sea. But right now, it was way before 1982 UNCLOS, or Convention on the Law of the Sea. And so there was an accident or collision course between France and Turkey boat or vessel. The effect of this collision course is that 8 or 10 Turkey vessel member were die in that accident or in that course, and then the officer and the captain from the French vessel, from the French boat, were arrested and criminally charged. The French government in here tried to protest the action from Turkish government, but they did not have any agreement, and then they bring the dispute to the PCIJ before it was changed to ICJ. So there are two principles by the court. France was actually trying to protest whether Turkey violate any international law or not. So that was one of the inquiry, or one of the main question that claim in this lawsuit for the Lotus case. But the PCIJ, the court, then state there are two principles. The first one is outside territory, and the second one is within territory. Which then the ultimate decision was actually simply saying that Turkey arresting officer and captain from the French boat was actually not violating international law, because the effect of this collision course that affecting some of the people or some of the member of the Turkish boat die was actually giving harm effect to the Turkey as a state, which then is actually kind of the extension of the territory of Turkey. So using the territorial jurisdiction, which then Turkey vessel with the flag state. However, this was then emphasized with the UNCLOS. So it was not, I think it was not really saying that it was not really emphasizing about the flag state at the time, but then it was emphasized after the UNCLOS that any vessel, any boat, or even airplane, according to the Chicago Convention as well in 1944. Space aircraft and then vessel or boat that having flag state, it will be an extension of territorial jurisdiction, whether if something happened criminally or even any kind of violation of international law, then that will be constituted as the territorial jurisdiction of those countries. In this case, is the Turkey vessel with the flag state at the time. So that will be saying, according to this decision on the Lotus case, Turkey did not violate any international law at the time. Okay, that is the example number one. Second example is actually it's not about the jurisdiction. So I don't know if this going to be a proper example or not, but I'm going to use it anyway because it's also one of the human rights case that I think is pretty important. But this is showing, so again, this is not about territorial jurisdiction per se, but this is more about the jurisdiction as in how then a country should be applying the law within their jurisdiction to their nationals. So Singer versus Canada, Singer is a doctor who filing a lawsuit to Canadian court at the time, and then it was brought to Human Rights Committee. So Singer was a doctor, tried to claim that all of the unborn child, I'm sorry, this is not Singer, this is not the case. So Singer versus Canada is actually about the case on the, where Singer having a business. Sorry, I was mistaken with another case. So Singer has a business, was actually, the business was using, advertisement like the billboard and everything, the sign, using English language. But then there is a local law in Canada that's actually asking that in this region, in this state, or in this province, this organization, any organization, corporation, or business should be using French language as well, because maybe 50 or 60% in Canada people are speaking French in addition to English. And Singer try to filing a lawsuit asking that I have individual rights, and then this supposed to be I supposed to be allowed to using English as the part of my advertisement of my business. But then it was rejected. The claim was rejected by the Canadian court and also the Human Rights Committee, because those instruction, those local policy was actually stated in the Constitution of Canada in regards of using French, and also for any organization, corporation, entity, or business. So it's actually based on the legality principle, whether something is prescribed by law. Then if it's something is prescribed by law, as long as it's not going to violate any international law principle or human right principle, then it is allowed to be used. And then Singer in here cannot use that claim. So again, it's not about territorial jurisdiction, but it's showing then how then law can use their internal jurisdiction to be applied to their national. In this case, Singer is a Canadian, and then Canada law try to impose their national law towards the national, which is Singer over here. So I think that will be all. Ula, I turn back to you. Thank you very much. I'm happy to answer any question or discussion. Thank you.
Okay, thank you, Pak Eka, for the, I think it's very lightful explanations about the jurisdiction, because we have many things to highlight in the jurisdiction, including the limitation of the jurisdictions, about the territory, about the citizenship, and many other things in the limitation of the jurisdictions, and other in the universal jurisdictions maybe can apply in terms of the human rights in armed conflict. Yeah, maybe that's previously we talked about the Ukraine, Russia, and Rwanda case, and other cases that maybe it's universal jurisdiction might be applied. And yes, I don't want to make some conclusion because we have already discussed a lot of things in jurisdictions. But once again, jurisdiction is related to the state authority to make the law and enforce the law in the territory and to all the people in the territory. So, and it is many cases that related to the implementations of the jurisdictions, especially in the criminal jurisdictions and related to the armed conflict that we have discussed previously. Mungkin ada mahasiswa yang masih ingin bertanya tentang jurisdiksi, karena tadi sudah dijelaskan beberapa jenis jurisdiksi ya. Tadi sudah ada jurisdiksi ekstrateritorial, kemudian tadi ada masalah lotus case ya, sengketa antara Turki di Laut Lepas, dan itu juga terkait dengan jurisdiksi negara bendera ya, yang ada yang jurisdiksi yang digunakan di Laut Lepas. Yang itu kemarin sudah kita diskusikan, jurisdiksi yang berlaku adalah jurisdiksi negara bendera kapal. Ya, ada yang lainnya mahasiswa?
Ada satu tuh Bu, dari
Oh,
Eugene.
Ya, Eugene.
Yes,
Silakan Eugene.
thank you for the opportunity. I would like to ask a question which I just came up with. Maybe this is an example of a case, and I really don't know, because here's the question. For example, there's a criminal that was in Indonesia, right? A criminal in Indonesia, but then he escaped with a boat with the flag of Indonesia outside of Indonesia into the seas of Singapore, right? But before he could land the boat and stand on the ground, he was caught, but still inside the seas and inside the ship with the Indonesian flag. Now, here's the question. Would it be appropriate to call that still Indonesia's jurisdiction, or does it already include to be Singapore's jurisdiction, to so that Indonesia can't really capture, because the criminal is already inside the sea territory?
Okay.
Okay, thank you, Pak Eka.
Yeah, thank you for the question. So this I will say this like a hypothetical example, and usually this kind of hypothetical example is used for the entrance assessment or UAS in my university, using this kind of hypothetical example. So Eugene actually just give me question based on hypothetical example that giving me UAS for myself. But anyway, thank you for that. But my clarification before I answer your question: who was the one caught this person from Indonesia? Is it the Indonesian official or the Singaporean official? I think it should be clear for the first time. You said that someone people caught them,
Indonesian
right?
or who?
Singaporean.
Singaporean or Indonesian?
He was Indonesian.
Yeah, I know that the person is from Indonesia, but there are authorities or officials who caught this person, right?
Oh yes, it
Which
was
country is this?
Singaporean.
Singaporean, okay.
Yes.
I do not know which crime that you are talking about here, but let's say if he is violating the border of the sea, like say without permission, there is a hot pursuit principle based on UNCLOS. Let's say if the crime is this person with the boat of Indonesian violating the border of the Sea of Singapore, then it is allowed based on the UNCLOS with the hot pursuit principle to directly getting this person caught if that is the violation. So in this case, if that is the example you would like to talk about, then in this case, Singaporean official is justified to doing that, to getting the person caught, because maybe the crime is violating the border of the Sea of Singapore. Okay, if that is the problem. But if the problem is something else, let's say like maybe in the past this person is committing a crime in Singapore, and right now he is going back, I don't know, for some other reason, then it should be, well, theoretically it should be when this person is land on the territory of Singapore. But however, I mean, there are some other things that might have to be considered for in the terms of getting this person to getting caught or arrested. So yeah, so again, my main answer would be based on the crime, based on what kind of violation. But I think safely to assume it will be the violation of the border of the sea, or the violation of the Singaporean border in this case. Okay.
I see. Thank you, sir.
Yeah, welcome. You're
Maybe for one last question. One last question. Raineri, you want to ask some question again?
Yes, ma'am. Okay,
Silakan.
okay, thank you, sir. So my question is that before this, you explained about the nationality, which is Yusangwes and Yusoli. So as far as I can recall, when I'm in junior high school, I learned about that, and there's some circumstances when someone born with two nationality at the same time, and they can choose which nationality they want to. But what if someone born in the no man's land, like I think we can call it apatrid? Yeah. So how does that work? Thank you.
Okay. Apartheid. I don't know if I getting that correctly, but if you're saying apartheid, I don't think it's referring what you were asking earlier, because apartheid is something else. It's about political that based political political policy, or political action that based on discriminatory action that happened in South Africa. One of the initial
Sir,
example is,
pardon, sir.
okay.
What I mean is, when I'm in junior high school, we call someone born with two nationality bipatrid, and someone born with no nationality apatrid. It's not apartheid. What I mean.
Okay.
Sorry.
Okay. Yeah. Sorry for mishearing that. So if you say that it's dual citizenship, I don't think they can be called as stateless. Oh, I'm sorry. I don't think they can be called as not having citizenship. They do have, but it will be dual citizenship, and they can, as I said earlier, it will be depends on the country. But in Indonesia, as I used the example earlier, they can choose any of these two citizenship whenever they turn to 18 years old. So that's based on I think that's based on the Undang-Undang Keimigrasian, or Immigration Act in our country. So they can choose to be Indonesian or any other citizenship when they are 18 years old. So it is the reason is that a person or individual can be considered as a person who is mature enough, and then can take action based on proper legal reason whenever he can be a legal subject, which is in this case is whenever this person is turned to 18. So if that is your question, then based on Indonesian law, I think what I'm last time I recall is actually, as I said earlier, it will be whenever this person turns to 18. So he or she should choose which of the citizenship or nationality he would like to permanently hold until this person die or so on. Yeah. So that would be my answer.
Pardon, sir. What I'm asking is, what if someone born in no man's land, like they born in an island but no country territory? So how does the citizenship works? Thank you.
Yeah, there's a couple. I mean, the example that I'm going to use may be not related to your question, but for example, like there's a status of government in exile, like Tibet, if I'm mistaken, those people within their jurisdiction is actually having nationality, but to some other countries, the country is not recognized. Hopefully, this related to your question. So the problem is whenever they're having, international relation or action that might be they're doing something or they're having action or conducting some activity that might be crossing border of the countries, that would be causing a problem. So the protection in here is maybe based on some of the international law, but I do not recall if there is any particular example that I can use in answering a question. However, in the term of stateless, maybe using the Refugee Convention is maybe one of the international law that maybe can be solving this issue. But again, I'm sorry that I can give up a really specific example in this situation. But it's what I'm understanding for the person who is being stateless in this situation. Okay.
Ya, thank you Pak Eka. Jadi terakhir hari kalau misalnya ada seseorang yang melahirkan di di tempat yang mungkin tidak ada negara yang di situ ya, atau misalnya tempat antah berantah, misalnya dia terdampar di pulau yang nggak tahu itu punyanya negara apa gitu ya, tapi kan itu bisa dilacak orang tuanya kewarganegaraan apa gitu ya. Tapi hukum internasional memastikan bahwa seseorang itu harus punya kewarganegaraan. Ya, harus ada yang mengakui dia itu warga negara mana. Entah itu kita pakai prinsip ius sanguinis atau ius soli. Memang faktanya ada kemungkinan satu orang itu memiliki kewarganegaraan ganda, tapi pada usia tertentu dia harus memilih dia ingin ikut kewarganegaraan apa. Tadi sudah dijelaskan oleh Pak Eka, 18 tahun atau 17 tahun gitu ya, kemudian kita harus memilih kewarganegaraan. Jadi hanya satu, tapi tidak semua orang di dunia ini harus punya nationality, jadi nggak stateless gitu ya. Okay. We have 2 minutes left. Maybe you want to make closing statement or something else, Pak Eka, before we close our class today, and you will continue for the next 2 hours ya. Maybe for the next 1 hour or next 2 hours. Maybe you will have another class for 30 minutes. Okay, I think it's enough for today for this meeting in international law class. This is here consists of two or three classes here for class D, class A, and class B. And once again, thank you very much, Mr. Eka, for your very, very enjoyable explanations. And hopefully we will meet again in another classes. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, sir.